Good evening, everybody. It's actually pitch black outside here in Galashiels because it's now 9:30. This won't be particularly long. I noticed that Linda K. Listening is doing a live chat in about 2 hours' time. So that's one reason. Not that I would keep you for 2 hours unless it was marathon, but also the StreamYard limit is 20 hours and I'm up to 18 and a half, and it doesn't reset till Friday. So might as well use my time wisely. Clearly, one of the things that keeps cropping up time and time again is the fact that the prosecutors enjoy immunity from anything that they do wrong, or at least seemingly so. So did a little bit of digging around, found an excellent article by, let me get the name right. So I'm going to go through the start of an article. It's not a particularly long article, but hopefully get through the first half of this article by Kaminsky. Hope I'm pronouncing his name correctly. An article that he actually wrote 20 years ago, more than 20 years ago. Nowadays, as you can see here, Irwin is the 13th Dean of Buckley Law. He joined the faculty as the Jesse Chopper Distinguished Professor of Law. Prior to assuming this position from 2008 to 17, he was the founding Dean and Distinguished Professor of Law and Raymond Pike Professor of First Amendment Law at the University of California. Before that, he was the Alston and Bird Professor of Law and Political Science at Duke University from 2004 to 2008, and from 1983 to 2004, which is the period from which this article is from, was a professor at the University of Southern California Law School, including as the Sidney M. Ermis Professor of Public Interest Law, Legal Ethics, and Political Science. He has also taught at DePaul College of Law and UCLA Law School. He is the author of 11 books, including leading case books and treatises about constitutional law, criminal procedure, and federal jurisdiction. Okay, so let's have a look at his article, which was presented in 1999 at the Taurus Law School, Toro, a law school, I believe, in New York. So this was Professor Irwin. And I'll just read through it and see where we get to this evening. My task is to discuss prosecutorial immunity. In order to discuss this, it has to be put in the broader context of absolute immunities. I am going to focus my remarks on 3 questions discussing absolute prosecutorial immunity. The first question is, what are the general principles of absolute immunity that also apply to prosecutors? Second, when can prosecutors claim absolute immunity as opposed to just receiving qualified immunity? And third, from a practical perspective, how is the distinction between absolute and qualified immunity for prosecutors applied? There are a few important general principles of prosecutorial immunity that I can identify. First, it's important to remember that absolute immunity applies to the task, not to the office. Judges have absolute immunity for their judicial acts, but not for their administrative acts. Legislators have absolute immunity for their legislative action, but they only have qualified immunity for their administrative acts. Now, I just want to quickly go back up here and just look at some of this at the very beginning, which might be relevant. As I say, this is an article actually from 1998 that was given at the Practicing Law Institute's 14th Annual Section 1983 Civil Rights Litigation Program. And I should explain, 1983 is actually not a year, it is a section of law, as we got here. While the Supreme Court has held that individuals performing certain functions have absolute immunity from liability under Section 1983, the court explains that the presumption is that qualified rather than absolute immunity is sufficient to protect government officials in their exercise of their duties. So as I say, 1983 is the number of a section, as you can see here, mentioned quite a few times. Okay, I just wanted to get that sorted out. I say the Toro Law Review. Carrying on, prosecutors have absolute immunity for prosecutorial acts, but not for investigative and not for administrative acts. There are several implications from this basic statement that absolute immunity attaches to the task and not to the office. One implication is that others who perform the task can also claim the immunity. So, for example, lower courts are increasingly finding that those besides judges who are performing judicial tasks are entitled to absolute judicial immunity. For example, O'Neill versus the Mississippi Licensing Board says that because a state licensing board for nurses is really performing an adjudicatory task, especially in considering license revocation, that board receives absolute judicial immunity. In Collier versus Darling, another lower court case stated that where a personnel board is adjudicating, that board is entitled to absolute judicial immunity. The notion is that since the immunity goes to the task, it does not matter who the individual is performing it. The same is true with regard to prosecutors. For example, there are a number of cases that say when social workers are functioning essentially as prosecutors, they are entitled to absolute prosecutorial immunity. So, in another case, Ernst v. Children. Let me just hold it there for a moment, because I've just realized that I am not currently sharing the screen, and that would be most beneficial if I was to share the screen, would it not? That would definitely help. Okay. So let's get back to prosecutorial immunity. As I say, I'll just quickly show you what I was talking about earlier. Here's Erwin Kaminsky. And there's his brief CV. As I say, we're looking at an article that was written by him during this time period when he was a professor at the University of Southern California Law School. Hopefully that's come up for you. Let's just do this as well. Let's just click on this and make that the full screen so that you can see better. And let's come back down to, don't worry, the juicy bits of this article are still to come. So it says here, the same is true with regard to prosecutors. For example, there are a number of cases that say when social workers are functioning essentially as prosecutors, they are entitled to absolute prosecutorial immunity. Ernst v. Children and Family Services and Thompson versus Scan Volunteers. Both were instances where courts said that since the social workers were functioning as prosecutors, the task was prosecutorial in nature, and they are entitled to absolute immunity. There are some cases that go the other way regarding social workers allowing only qualified immunity, and I have listed them as well. Marty Schwartz this morning pointed out to me a recent decision of the Fourth Circuit that follows this in another context. The case is Eugene versus Collins, where the question was the liability of police officers for not turning exculpatory material over to a defendant. The Fourth Circuit en banc said that police officers have absolute immunity for failure to turn exculpatory material over to a criminal defendant because police in this capacity are performing a prosecutorial task and are therefore entitled to absolute immunity. Oh, it sounds completely bizarre, doesn't it? Eugene versus Collins also addressed the issue of the liability of the police for not turning exculpatory material over to the prosecutor. There, the Fourth Circuit said it was qualified immunity, and that because it was not clearly established law, the police were not to be held liable. But I use the case as another illustration of how courts say that when somebody is performing the task, they are entitled to the immunity. The other implication of this, to which I have already alluded to, is that prosecutors are performing non-prosecutorial tasks, or should I say when prosecutors are performing non-prosecutorial tasks, they are only entitled to qualified immunity. If the immunity goes to the task and not to the office, then that explains why the prosecutor who is in a non-prosecutorial role just gets good faith immunity, where the judge in the non-judicial role gets good faith immunity, and the application carries across the board. The second general principle that is important here is that often the availability of absolute immunity depends on the relief sought. This is certainly true with regard to prosecutors. Prosecutors have absolute immunity as to claims for money damages, but prosecutors have no immunity as to claims for injunctive relief. Indeed, Ex parte Young long ago held that prosecutors can be sued for injunctive relief. One of the key ways around the 11th Amendment is to sue the Attorney General in federal court for injunctive relief. To give prosecutors absolute immunity here would create an enormous obstacle to applying federal law in the states. Now then, legislators, in contrast, have always been thought to have both immunity from suits for money damages and from suits for injunctive relief. For judges, the story is even more complicated. In Pulliam versus Allen, the United States Supreme Court said that judges have absolute immunity in suits from money damages, but no immunity in suits for injunctive relief. If the judge is successfully sued for injunctive relief, the judge could be liable for attorney fees under Section 1983. The judges did not like this very much, and they tried very hard to lobby Congress for a statute to amend Section 1983 to create absolute judicial immunity to suits for injunctions as well. When Republicans gained control of Congress, finally, the judges had a receptive audience. Indeed, 2 years ago, a statute was adopted, which is quoted within the materials, that now gives judges absolute immunity in suits for both injunctive relief and for money damages. There is only a very narrow exception if the judge violates prior to declaring judgment. The final general principle to remember is that absolute immunity is a judicial creation, not a legislative requirement. There is nothing in Section 1983 that speaks of immunities at all. All immunities, whether they are absolute or qualified, are a product of judicial decisions. In discussing prosecutorial immunity, the crucial distinction is between prosecutorial and investigative. It is important to recognize that since the court has created this distinction, the court, not the legislature, gets to decide its contours. Congress always has the ability to overrule the court by amending Section 1983, as it did for absolute immunity for judges to injunctions, but otherwise the court is creating the immunities. When the court creates absolute immunities, it says it is looking both to history and function. The Supreme Court says Section 1983 was written against the backdrop of common law immunity. It looks to the nature of the immunities as they existed in common law when Section 1983 was adopted, and if an official had absolute immunity pre-Section 1983, then that official has it now. I am skeptical about this historical analysis. For example, consider judicial immunity as articulated in Stump versus Sparkman, in which the Supreme Court held that judges have absolute immunity in suits for money damages. The Supreme Court based this in large part on history. Professor Randy Block wrote an article in the Duke Law Journal, in which he went to a survey of every state that existed in 1871. So this 150 years ago, 149 years ago, and which ones did and did not have absolute immunity for judges. He found only 13 of 37 states had absolute judicial immunity in 1871. Yet the Supreme Court cites to those 13, ignoring the fact that the majority of states rejected absolute immunity. I think the functional analysis is more important to the court. The court says that for those officers who are likely to be subjected to repeated suits, there is a need for protection. For those officers where the suits are likely to chill the excess of discretion, there is a necessity for protection. And that is why the court has said the president has absolute immunity in carrying out the tasks of the office. The Supreme Court said police officers testifying as witnesses have absolute immunity. In Briscoe versus LaHoo, the court enumerated the same factors which lead it to that conclusion. The same factors support its conclusion with regard to prosecutors. The reason I am emphasizing this is that there are likely to be many other officers who want to claim prosecutorial immunity. I mentioned social workers. I think the arguments here, in part, will be about history, but even more, they are about function. Is this a kind of function that warrants absolute immunity? Is it a prosecutorial task, or an investigative task, or an administrative one? With those general principles in mind, I want to go to the second of the three questions I said at the beginning, which is, when are prosecutors entitled to absolute as opposed to qualified immunity? The only way that I can answer this question is to tell you that there have been 4 Supreme Court cases. All 4 cases say prosecutors have absolute immunity for prosecutorial acts, but only qualified immunity for investigative and administrative ones. And if you litigate in this area, you simply need to rely on these 4 cases for guidance. Let me go through them one at a time. The first is Imbler versus Parchment. Imbler involved a prosecutor who knowingly used perjured testimony. As a result of the perjured testimony, an innocent individual was convicted and served 9 years in prison. Only after the true culprit was found did the individual learn that his conviction was obtained because of the use of perjured testimony. A suit was brought against the prosecutor. The United States Supreme Court for the first time articulated this distinction between absolute immunity for prosecutorial acts and qualified immunity for investigative or administrative acts. The Supreme Court said using testimony at trial is quintessentially a prosecutorial action, so the prosecutor had absolute immunity to a suit for money damages. The court said that there may be other actions against the prosecutor, perhaps a criminal prosecution, bar disciplinary action, and administrative action within the office, but no civil suit for money damages could be brought even though an innocent person spent 9 years in prison. The next time that the Supreme Court turned to this distinction was in Burns versus Reed, a case of particularly colourful facts. It starts with a tragedy. A woman awoke to discover that both of her children had been shot. Thankfully, both recovered. The police focused on the idea that the mother shot her own children. They gave the mother a lie detector test and she passed. They gave the mother a voice stress test and she passed. The police saw some writing in lipstick on the mirror. Someone had written, "I have taken from you what you love the most." Thereafter, the police had the handwriting analysed. It turned out that the writing in the mirror was made by a left-handed person, and Kathy Burns, the mother, was a right-handed person. She was completely exonerated of any wrongdoing. Still, the police had no suspect. Then a police officer developed a theory. Maybe Kathy Burns had a multiple personality disorder, and one of her alternative personalities was responsible for the shootings. At that time, according to the Seventh Circuit opinion, the police officer had a friend, a grocery store clerk who had just completed a course in hypnosis. The police officer called the prosecutor, Rick Reed, and asked if he could have Kathy Burns hypnotized to see if she had multiple personality disorder. The prosecutor approved the hypnosis, and Kathy Burns was hypnotized by this grocery store clerk. Apparently, at one point, she referred to herself with another name in the third person. Based solely on this, the prosecutor went to court the next day for an arrest warrant. The prosecutor never disclosed the hypnosis to the judge. Additionally, it was never disclosed, for example, that Kathy Burns was told under hypnosis to fully answer all questions put to her by the police. Kathy Burns spent 4 months in custody, temporarily lost custody of her children, and lost her job. No evidence of any wrongdoing was ever found against Kathy Burns, and she was released. Kathy Burns sued the police officers and the prosecutor. The prosecutor claimed absolute immunity. This went to the United States Supreme Court. The Supreme Court said prosecutors have absolute immunity for prosecutorial acts. Requesting an arrest warrant is a prosecutorial act, so there could be no liability. But the Supreme Court said prosecutors have only qualified immunity for investigative acts. The Supreme Court said authorizing hypnosis was investigative in nature, so for that purpose, he had only qualified immunity. The third of these cases was Buckley versus Fitzsimmons. Buckley involved a high-profile murder case in a county outside of Chicago. Shortly before the election for district attorney, the incumbent held a press conference and announced the arrest of the murderer in the case and claimed that the person placed under arrest had committed these high-profile crimes. After a long time in jail, it turned out that there was no evidence to link the defendant to the crime. The defendant was released and brought a civil suit against the prosecutor. There were two grounds for the civil suit against the prosecutor. One concerned the press conference. The other concerned alleged fabrication of evidence. There was a boot print at the murder scene, and the prosecutor went to a number of experts to see if those experts would link the defendant to the boot print. One expert after another said that there is no indication that this boot print came from this defendant. Finally, the prosecutor found an expert in North Carolina who said, "Not only can I match the sole, the shoe, to the defendant, but I can tell you that only the defendant could have left this boot print." She said that she had a method where she could tell by the distribution of weight who exactly left a footprint. She said that each one of us has a unique way of walking, and from looking at a boot print, I can tell you that was this defendant. The prosecutor found no one else who would say this, but this was the key evidence that was used to keep the defendant in custody. Now, subsequently, all charges were dismissed. Thereafter, a suit was filed against the prosecutor, not only for the press conference, but also for shopping for a new witness and fabricating evidence. The Supreme Court unanimously held that prosecutors have only qualified immunity for what they say at press conferences. The Supreme Court said such conduct is not prosecutorial in nature, is not even investigative. At most, it is administrative or public relations in nature. Furthermore, the court stated in a 5-4 decision with regard to fabricating evidence that it is only protected by qualified immunity. When a prosecutor is alleged to fabricate evidence, the prosecutor is engaged in an investigative task, not a prosecutorial task. Here, the prosecutor went shopping for an expert witness to say what the prosecutor wanted. And that is the kind of investigative task usually performed by police officers. not prosecutors. So for this, only qualified immunity. I find this part of the holding troubling in trying to come up with a clear line between what is prosecutorial and what is investigative. Why does a prosecutor go to get an expert witness to use that person at trial? Well, why then is shopping for an expert witness to be regarded as investigative rather than prosecutorial in nature? Now, I think we'll leave it there and we'll look at this fourth case at a future time. Hopefully not too long. So let's come back to the main screen and close that off. I mean, it beggars belief when you hear some of these stories, and imagine that a footprint expert that can say that she could tell it was definitely that person just by the way they walked. It's a bit like our Manitowoc politician who could tell Stephen Avery was guilty just by the look in Steve's eye. It just beggars belief, some of this, some really bizarre stuff. Anyway, I'm kind of hoping as I say, I have a limit of 20 hours on StreamYard. I'm up to, it'll be about 19 hours now, so I've got about 1 hour to go. Maybe Friday when it resets, I'm hoping to have a chat with Millbilly at some time soon, to do with Marathon, and I know that he's quite excited about some stuff that he's investigated recently. So watch out for the Millbilly channel. As I say, later on tonight, Linda Kay listening. One word: bizarre. It's just totally bizarre. It's pretty crazy when you read those sort of accounts of what the prosecutor was getting up to. It is pretty bizarre. Let's just leave it at that. Anyway, watch out, as I say, for the fact that Linda is going to be, I think, in about an hour and a half's time. And watch out for, as I say, Millbilly, that's going to be doing looking at some other things that he's discovered in, I think, in some of the phone calls or the interviews or whatever, in some of the tapes that he's looked at. So anyway, we'll do part 2 and we'll look at the fourth case maybe later on in the week. Okay. Yeah, the marathon went very well as far as certainly as far as I was concerned. Very, very good to see all the different hosts, to see the new hosts, and bear in mind that next year people who are in the audience could be the guests next year, and could even be the hosts themselves. You don't need anything special to post videos, and sometimes it's I know it's a poke in the eye of the guilters when they see more and more people coming forward. Finally, you're probably wondering what that is that's written behind me. I'll move out the way so you can see what it says. It says, "Wonder why so many crimes are committed." Wrong way. Are committed by lawyers, police, judges, and governments. Well, I think prosecutorial immunity is definitely one of those, don't you think? Okie dokie. As I say, I better say cheerio for now, and we'll catch you all again soon. Bye for now.